Yes, we are going live.
Here we are, folks.
Howdy doody. How you doing, JR?
Good. No complaints.
Wonderful. Yeah, I think you're a little chilly though, right?
I'm cold, but that's about it. It's
Yeah, I
freezing
don't
down here.
get this. It's 80 degrees outside where JR is, and he's freezing. You
You
know,
know, let me tell you something. There's something to be said with for geothermal, heating and cooling your home because in the summertime in this basement, I'll bet it's 62 degrees down here, and there's
I,
no air going. It's freezing. I'm freezing.
yeah, I have a different interpretation, of course. I think that JR might be postmenopausal, in my opinion. My opinion. You
No,
never
those are
know.
heat flashes, not.
Well, for a man, maybe it's the reverse impact. Anyway, glad to be here with JR today. And I think I did a video yesterday talking about this. We had just received the receiver's report. It's very lengthy, had a lot of content. So I said we come back and we do our best to kind of explain it. What we're kind of do is JR is going to react fresh. So he hasn't looked at it. I'm going to kind of make some comments. So what I'm going to do is I'm going to literally go through the document. And I think I asked somebody to check the receiver's website. And if it wasn't on the receiver's website, to send an email to the receiver to post it on the receiver's website. But I'm going to cite to the document. It's the only thing I'm going to do is talk about the receiver's document. It's a public document. It was filed May 16th. That was yesterday.
Yesterday.
12:10 p.m. Pacific time, so 3:10 Eastern time. And we're just going to talk about that. And again, we'll just get some commentary. Now, I was told, and it kind of bothered me, to be honest. And I understand the anger. So, a lot of people are pissed off at the prior management. That's perfectly understandable. I'm with you. Obviously, I'm with you on that. But apparently some people reached out directly and made some kind of questionable comments. And one, and this is not legal advice, but that's probably unlawful or tortious. So from a legal standpoint, it's not that you shouldn't do it. From an ethical standpoint, you shouldn't be threatening people. And from being productive for the cause, you shouldn't do it because it'll be used as an excuse. We've seen it already, like in MMTLP. It's used as an excuse to kind of say that everybody's bad and they have no merit to their position and screw them. So I understand if you're angry, but let's have a different way of expressing your anger tonight. So what I'd like everybody to do, if you stay with us, because this might be a little detailed, if you stay to us or as long as you stay, at the end, put a comment. In essence, I want you to react to what you hear and express whatever emotion you have in a comment. And if everybody could do that as opposed to doing something in a negative fashion, let's see what how the community as a whole feels about what's reflected in the fourth interim receivers report, which we're going to go over. Anything else you wanted to say, JR, before we start?
No, let's go.
Okay, let's go. Of course, before we start, I wanted to ask you.
I thought maybe you forgot about
them. No. Where do atheists donate their money?
Not church.
No, that's
I don't know.
To non-profit organizations. PROPHET.
Oh, yeah.
Got it. I can spell it. I got to spell it. Did you hear that starting Monday, NASDAQ is going to start allowing the trading of mushrooms? Because you didn't hear about that. The SEC is determined that mushrooms are fungible. A politician, a liar, and a securities fraudster enter a bar. He sits down and orders a martini. You'll have to play that one back. And last but not least, someone challenged me to tell a pun about very crooked teeth. Now brace yourself. Oh, man. Oh, that was pretty bad.
Those were not good, man.
Thank you. All right, so we're at the receiver's report. Well, interesting. Before we start, I looked up. Everybody's heard about the term Ponzi scheme. You've heard of that term, right? And did
Yes.
you presume that must have been after somebody? There must have been a Ponzi.
Oh yeah, there was. I think that's
Yeah,
who
there was a
it was named
Charles.
after somebody.
There was a Charles Ponzi, and Charles Ponzi was an Italian immigrant who ripped off people in the United States and Canada, like in the early 1900s. Yeah, early 1900s. He became so famous that they named the Ponzi scheme after him. But he learned his craft from some guy named William Miller, who was some CPA bookkeeper who ripped off a bunch of people. And with Charles Ponzi, he used discounted postal reply coupons, and he did some kind of arbitrage BS something. So it's interesting. I found about that. Well, you know what's interesting is I had an opportunity to speak to two very, very well-known perpetrators of fraud. I spoke to both Mr. Ponzi and I spoke to Bernie Madoff about GTII, and they said that's corruption even beyond them. They wouldn't have engaged in that kind of behavior. Hard to believe, but whatever. So this report was prepared. It's been worked on for quite some time. I'm just going to kind of go through sections. We'll talk about sections. There's too much content to really kind of like to spend all the time. We'd be here for a half a day. So the first thing is, we talked about the audit. The audit is done, except that apparently there's a bunch, and I'm looking at page 3 of 41 of the report, just so we have a record of where we're looking. There's a reference to a bunch of lawyers who didn't sign certifications on for the audit, and that's what they're awaiting. All the information to be obtained, but they're waiting for these gentlemen. I think they're all gentlemen. No, one is a female. They're waiting for them to sign off. There's no reason why they haven't signed off. I've dealt with 2 or 3 of them. Some of them, just might as well point it out, because we talked about this. Jack Fattel, do you remember that name?
Yeah.
That was the guy that communicated with me about like the 10K was coming out and there was an acquisition. Do you remember that? That he was from Canada, I believe. Didn't make a lot of sense why he was involved, but he was. The things, if I recall, and again, this is not legal advice. This is all opinion. I don't have a perfect memory, pretty close, but not a perfect memory about this stuff. But he talked about things that I don't recall ever occurring, got pissed, and things progressed. And one of the reasons that I think this thing got moved ahead was because of my interactions with him that didn't result in what I thought they were going to result in.
Right.
Then there was another attorney by the name of Robert Hantman, and he contacted me out of the blue one time from New York. I think he said he owned like 800,000 shares. I think we spoke about it, by the way. And he was affiliated with GTI and Reichman, and he kind of was trying to intervene at one point in time. I know I discussed, this is just so it'll come out. So I know we discussed the general matter. I know he wasn't like overly supportive of Reichman, even though he was kind of an intermediary. And then some point in time, I think he inadvertently called me, and and this we did discuss because Kathy Griffin, remember, she sent me an email. This was another guy who sent it. He called me, but didn't know he was calling me. Didn't know who I was. I called him back. That's the same guy. Kind of like, okay. Then there's another person, is Terry Pham. She was the attorney, the firm that represented Reichman and Nabari and GTI in the suit against me, in the defamation suit, and in the action that was in Vegas originally. Then they got bounced, or they left, or whatever, and the suit got dismissed. I'm not a big fan of theirs, obviously. Also, I thought their action was bullshit. And no justification. So there's 5 lawyers mentioned. I don't know if there's any other individuals. The attorney for the receiver has indicated that if they don't get immediate cooperation, whatever immediate is, and I've had decent discussions now with the receiver's counsel, not that they're giving me inside information or anything like that, right, but we're at least communicating like I was the attorney for a party. That's the change. But he indicated that they were going to pursue it, and they will seek a motion basically from the court that if these people don't sign, the court will order them to sign, direct them to sign. Now, I don't think that would be the way I would go, but it's not my call. But might do it in the alternative. What I might do is set a OSC, an order to show cause, and say, listen, this is what the documents say. If you disagree with what the document says, then come into court and tell us. If you don't, we're going to assume it's true, and the court's going to sign an order, and that's going to be a certification. You're going to have certified the document, and the auditor will then rely upon it. Your choice, either way. I think that would be a little stronger than doing like asking the judge to order them to do it, because it's probably not going to be the end. If you set it as a hearing now, that you give them the opportunity to say why they don't want to sign it. Okay, they may have a good reason. Give them the reason. If they don't have a good reason, then they make it in effect. They have agreed to the execution. The auditor apparently won't sign off without the certifications. At least they won't yet. And they weren't willing to accept some kind of note like that Mr. X, Y, and Z didn't sign off, and you should consider this financial statement with that as an understanding. They weren't willing to sign off on something like that.
Why are those attorneys required to sign off on a financial
because apparently they either have income, they were parties to. I think they're going to have some kind of financial involvement. Like I know, for example, Fattel was an attorney, so he got paid. Right. Yeah. So I think it's going to be, I'm speculating, completely speculating. So the attorneys did stuff. Somebody might have not done something 100% kosher here.
It's stuff for what, though? Did what? What if they
let's say they got paid stock, maybe they got paid in stock. I'll create a situation. Let's say attorney X 5 years ago got paid in stock and didn't declare it, let's say, and owes IRS money. And that would be a felony, theoretically. So maybe if you were in that position, you wouldn't want to verify the document. Or maybe if the number wasn't correct and it was more, you wouldn't want to verify the document. Maybe you wouldn't want to disclose it. There could be all kinds of reasons, probably not a good reason, though. I mean, if in effect you were paid $25,000 and you had a certified you got paid $25,000, that doesn't seem to be like an overly complicated scenario. But if you got paid, $1 million and it shows 25,000.
So are they signing off on addendums to the?
It's called a confirmation. It's a confirmation letter from counterparties. That's what it's called. Okay. And it's the auditor's requirement. So the auditors finished everything. They got all it's done. It's just waiting for those confirmation letters.
Okay.
There was previously there was some missing information, but that was obtained. So it's not a problem anymore. But these guys have to.
Is the report? I'm assuming the report is silent on the contents of the confirmation letters.
I haven't seen the report, so I wouldn't know.
Oh, okay. The auditors.
Yeah.
Okay.
Yeah, I haven't seen it, so I don't know. I just know
now it makes sense.
Yeah.
When you said certification of the financials, I was confused. Why would attorneys representing the company need to sign off on certifying the financials? But now I'm getting it. Okay. Yeah. It's clicking for me.
Yeah. So somebody's like concerned about doing something, and that's why they're probably not doing it. I can't tell you why they're concerned, but they're concerned. Again.
Well, how long were the letters sent out to all these parties?
I think it's been at least trying to think of my understanding. I would say, probably like 30 to 60 days.
Oh, yeah.
Yeah, it's not like it's like a week or 2 weeks. Enough time that somebody's not moving forward. I think that's the idea. So they're going to try to do a workaround, and it's not I don't think it's an easy workaround. I think it's doable. I like the way I did it better than the way they did it myself. But I don't know if a court's going to grant it those ways or there's another way to do it, because they're not parties to the action at this point.
Well, I think the court could just say that, I think the court could just move to certify them whether they sign off on them or not.
No, I don't think so. I don't think so. But I think in the receivership, I didn't look, but I think in the receivership order, it might reference kind of like,
Well, here's the
Reichman, his agents, his attorneys. It might like list everybody. So implicitly, they may be party to the receivership order. And I think the argument will be they're in breach of the receivership order. And that if you go into court, that's what you're going to claim. They breached the receivership order, then sign or enter the signature. I myself would go for the gusto and go for the entry of the signature. By the way, might as well talk about this since we talked about it before we go on. So I'm going to be, so again, I don't quite understand what's going on. And I told JR, what I said in one of my recent videos, apparently there are people that are watching that are not on our team. I will leave it that way. And they weren't happy with some of the content. And part of it is what I mentioned before, that there were apparently contacts that were offensive contacts, and that we don't support, we don't encourage. But the other part is because they don't like us talking about, bad stuff about their client. Unfortunately, this is like the documents in the court file. So it's a public record.
They don't like us reading from the document that makes their client look bad.
Yeah, they don't like hearing what the document says their client did is really
Publicly.
the problem. Yeah.
Public.
I mean, and there's
and folks, it's because normally shareholders don't pay this close attention.
Yes. Yeah, you wouldn't get it. And we wouldn't have got it either. We normally wouldn't have got it anyway. If just think about it this way, if the receivership hadn't been successful, despite whatever reservations, whatever concerns we have about the receivership, if the receivership had not been established, we would have never seen any of this stuff.
No.
This company would have gone bankrupt, folded up.
And we would have never have known the truth.
It would just have been another company we would have bitched about and not known the extent of the depravity that apparently went on based upon this report. And again, I don't know because I'm not the investigator. All I did was the early stuff where it just smelled bad to me. The receiver, it's 4 reports and it's, pretty bad. So anyway, one thing is the issue of the certification. It's being worked on. So just to let everybody know, it's not being sat. I expect, and somebody asked me today when they thought it was going to be traded. I forgot who asked me, by the way. Fox Hunter. I think it was Fox Hunter. I think it was Fox Hunter.
I think they're on. I thought I saw them make.
Oh yeah, I think he asked me when they're going to be traded, and he asked a month, 3 to 6 months, and I said, pure speculation on my part. But if I was going to, guess, I'd say more inclined to the 3 to 6 months than the 1 month, that kind of period. And that's because I think to get this certification done, to get the emotion I'm going to talk about in a second heard, it's probably going to take that kind of period of time, realistically.
Right.
But what I was going to say before we go on, so we have that, and they don't want to hear us. And I'm in an unusual position here, right? I really do think, by the way, I'm not familiar with another case where like this situation came up. A party was also an attorney who split from the main plaintiff group to be on his own, to be able to do what he wanted to do. So, for example, and this is kind of the fun part, and I just started thinking about this, and I'm not officially the attorney of record until the 27th. There's a hearing on the 27th. But if I'm the attorney, I'm the attorney for myself. There's nothing to stop me from taking David Reichman's deposition. So, and what I intend to do, and I don't know how it's going to work out, because there may be reasons why it wouldn't be helpful, and I'll listen to anybody. But after the 27th, when I'm attorney of record, my first email shall go to counsel for Mr. Reichman, while I will graciously ask for dates for his deposition in Los Angeles, which is very inconvenient for me being in the Los Angeles area, but I will accommodate him wherever he'll be. I expect to get pushback, delay, whatever, but ultimately, one way or the other, either there is going to be a resolution where I don't need to take his deposition, or I will, or some other counsel will, and I will be there. And we will go. And if I need to take Justine Reichman's deposition, I will do that too. And you'll see that she's referenced throughout this document. I was really careful, by the way. I'd heard rumors and concerns expressed about her for quite some time. I did not discuss that. Yeah, I'm only discussing because it's blatantly referenced in this fourth report, and we're going to go through it. But after you hear it, you will understand why maybe she would be a good person to depose. Now, she was deposed as the person most knowledgeable with .8. That was the company that was located, I think. It's located in multiple places. That's all I can say, and you'll hear why in the hearing. But she testified there, but nobody's taken her personal deposition. And now, since I'm on my own, and it's kind of a wild card, I would personally, if I were in the shoes of the defendants.
Oh my God, I just read item number 3. Holy shit.
Which item is that?
Oh, my bad. My bad. I misread the number.
Okay. All right. Okay.
Sorry.
Okay. All right. But anyway, so we'll see how this plays. And again, it's kind of like a wild card because I'm not limited. I have, listen, I'm going to act in an ethical way. I'm not going to do anything inappropriate, but I'm not going to be super patient. I'm not going to let time pass. And if they decide to take a different route, then so be it. I'm going to let the facts play out. Anyway, back to the document. So since the last report, they collected about $700,000. The total collected to date is about $1.4 million. That included, since the last report, they got about $67,000 back from Justine Reichman.
Yeah, when I looked at that, I thought it was 67 million. That's
okay.
That's why
we'll get bigger numbers. I don't know why. I don't know what
I was going to say, how come we weren't talking about that prior to starting? I pulled up the report, but it's on my phone, so I got to struggle to say it.
Okay, I don't know why, what the 67,000 was for, but whatever. Then it talks about that through some kind of, and a lot of these transactions appear based upon what the receiver report. I'm just going to use this for example. It's like Mr. X gives it to company Y gives it to company Z, and company Z puts it into a company owned by Mr. X. That kind of scenario. And the receiver throughout says, listen, and I'm summarizing kind of what their conclusion is, but the receiver says, listen, the way they did these transactions, if they had nothing to hide, they wouldn't have done them in that manner. They're only done to conceal and not be transparent. And there's no good reason for a lot of the I think most of the transactions referenced. In that specific section, it says that, so basically is money goes from Reichman to an entity, back to Reichman, to Justine, and then Justine then sends it to a contractor who does like $350,000 worth of, and I'm kind of rounding off, but about $350,000 worth of work on Reichman's condo, which apparently was bought with using GTII proceeds and now has a Liz pendency against it. In addition to that, there was a bunch of furniture that was apparently bought. That furniture is in storage in Van Nuys, which is near LA. And the guy architect apparently is ducking. He doesn't want to get involved, but they just served him apparently with a subpoena, and whatever. But that's kind of the stuff that goes on. His Land Rover, and we haven't gotten the good stuff yet, so this is like the summary. The Land Rover got sold.
Good.
And if anybody wants to, and they think it's worth about $100,000. If anybody out there wants to buy the Land Rover, please contact the receiver and make an offer, because it would be kind of fun if at least one of us got a good deal on a Land Rover, right? At least got to make some positive out of it.
So, they can park it in front of the SEC with a picture of Reichman's,
next to Ham's truck. They'll put the Reichman's vehicle, and right?
Oh crap!
Anybody who's interested in the Range Rover, please contact the receiver. As of the time of the report, the receivers clawed back about 21 million shares. The biggest amount was almost 15 million from Internet Capital, which is a company controlled apparently by Warren Moskowitz, who was also a lawyer of GTII, who I also had limited contact with. He's the one who I think he verified the dividend, or he certified the dividend. Do you remember there was a letter that had to be written?
Yeah.
He's the
He
one
certified it to, he certified it for the brokers.
right, which didn't help a lot, but that's what he did. And I guess, the bottom line is the receiver claims there's still 178 million shares that are trying to be clawed back, and they're in the process of clawing back an additional the 21 million that he mentioned.
They've already gotten back.
Yeah. There was a debt owed from Astra Energy. Do you remember Astra Energy?
Oh yeah.
Yeah.
Yeah. We interviewed that CEO.
We did. So they owe 225 apparently, and he's disappeared. What can you do? So they're trying to collect. Apparently, Astra Energy got some money from I don't know who, but they owe money like $225,000. But the CEO, maybe we put him over the top. We got rid of him. We kicked him out, but he's disappeared.
Interesting.
Yeah. Now, this is a summary of this is what the receiver believes has been illicit stock sales.
What page are you on?
I'm on page 5, item number 8.
Okay.
So illicit stock sales. So this is just sale of stock that apparently that the receiver believes the evidence shows there's no rational basis, legal basis for it. So I'm just going to read off the amounts. $2.9 million to Dot 8, which is a Wyoming entity, which is controlled by one or both of the Reichmans. Established by the former board of GTII. And apparently
given to Justine Reichman for $1,
which is a good deal in my opinion.
Did she pay the fair market value tax on that, like the IRS says you're supposed to?
I don't know, but that's
interesting.
It's a good question.
Yeah, that's interesting.
I think that's a good deal. If you can get $3 million worth of stock for $1, I think that's a good transaction. Some people might be suspicious that might be too good a transaction. That may not be an arm's
IRS.
Length. Yeah, it may not be an arm's length transaction. Considerably. I'm rounding $3.5 million in illicit stock sales from Mark Richardson for the benefit of Mr. Reichman. Richardson's was a lawyer, and apparently what he would do, and again, I don't know this, I'm just basing it upon what the report says. What the report claims is he would he'd get a bunch of stock, he'd sell it, he'd give 90% of the money to Reichman, he'd keep 10%. He kept like, it's a good deal. It's a good, you're laughing about it, but if you could get a gig like that, that's a good gig. I mean, for an attorney gig, listen, if you get 10% of all the sales, it's like, it's a great deal. But some people might think,
let's backtrack here a second. I mean, you and I are both attorneys. Isn't there some rule of ethics or professional responsibility? I mean, that doesn't sound right.
Well, probably, yeah. I think it might be problematic, I would say.
Okay.
I would say.
Checking.
All right. So most of that money went to Mr. Reichman, apparently. $2 million illicit stock sale by Markowitz for the benefit of Mr. Reichman. And I think that one, Markowitz kept like $200,000 and Reichman got $1.8 million. And last but not least, $5.2 million in stock sales by Justine Reichman. So the total amount, and again, this is an ongoing investigation, and the receiver says, there's a lot of attempts to conceal information. So it may be, if you keep on going, you keep on digging, you're going to find more and more. But just in illicit stock sales, they say it's approximately $14 million. Just imagine that. $14 million. What would $14 million do to GTII today? How would that be of assistance? You think that could be a beneficial use?
I'm sure Forrester could use it for something. What this reads to me like is what we have been talking about, that the Reichmans, now I'm going to use them both, plural, have been using GTII as their personal piggy bank.
Yeah, we said at the beginning. I speculated about that at the beginning. And
right. It's very clear to me in this report that is going to the court or has been signed off on by the court that that's what was happening.
Now we're at paragraph 9. Prior to 2000, so this is just for anybody who eventually looks at this, if they happen to sometime in the future and they happen to have the report in front of them. We're on page 5 of 41. Prior to 2018, there were a bunch of parties apparently that gave money to GTII, or there were notes, or apparently theoretically there were notes. And one of those people was Robin Besso, and she had a romantic relationship with Reichman. She apparently let him use her credit cards. She bought him a Bentley, I think. Now we're on page 6. She bought him a Bentley, and she paid for his living expenses at the Beverly Hilton Hotel. And I made a joke last week that there was a meeting, some kind of economic meeting, and Dissent was there, the government was there, and the opponents to the government were there. And the opponents to the government stayed at the Beverly Hilton Hotel, and Dissent and guys stayed at the Peninsula. And I said the Peninsula was far superior. But anyway, so Reichman was at the Beverly Hilton, financed by apparently this woman who got almost 12 million shares.
Yep.
So it did nothing. I mean, as far as I know, did nothing. And it certainly wasn't for the benefit of GTII. All those living expenses were David Reichman, according to this report, all of them were living expenses for his personal living expenses that were paid for, in essence, by GTII and all of you out there. All of you. And she has 11 million shares, apparently, or she sold them, whatever. So it goes on, and you got to remember, since 2007, because it says in the report, no revenue. Just think about this. 0 revenue. This company has 0 revenue since 2007, at least reflected in this. So in 2022, GTII received approximately $3.3 million from warrants. They had sold warrants that came due. And when the receiver went to the account that had that money, instead of that 3.3, there were now about $150,000 left. And you got to remember, there's no income, no revenue, no nothing. Just there's nothing going on. At least that's what the report suggests. And during that time, they spent $3.12 million on various things, like $715,000 on their American Express and $375,000 on Citibank. And when they looked at that spending, I think the conclusion was that it was personal expenses again. And he claimed, part of Reichman's claim all along was he was deferring his income. He wasn't taking income. But if you look at what happened, he more than took income. As a matter of fact, they analyzed that. They said, because his claim is he's entitled compensation for, working. Now, I don't think he did. I don't think he did jack, but let's just say he did.
Didn't his attorney make the argument that they should follow the sound business judgment rule during the AI-versity deal? Didn't Reichman's attorney make that argument about sound business judgment?
He might have.
Do you think this follows that rule, the sound business judgment?
I think the anti-sound business judgment.
Is this how a reasonable person makes a business decision?
Yeah. So here's the conclusion of the receiver in this section. As previously discussed, while Mr. Reichman claimed to be deferring his income, in reality, he was using GTIA assets to pay every facet of his life, including living at luxury hotels, paying for a Porsche and a Range Rover, and hundreds of thousands in dining expenses. The receiver will seek recovery of any expenses that are clearly not related to GTI business. So kind of what you said before.
Pretty much everything.
Yeah. It's like, and this is not like, being discreet. This is like, if you wanted to go out, I haven't looked at the bills, but kind of like sounds like it. If he wants to go out and spend $1,000 on a dinner, he'll go out and spend $1,000 on a dinner because GTI is paying for it, at least according to these documents. So why not? Now, this section, now we're on page 7. This section talks about stock volatility, and so the question, and this kind of talks about the shorting a little bit. So this is the first time I kind of liked it a little bit, because in this section we talk about the concentrated short position. It comes up. So the issue is, why was the stock so volatile? Why, did it have like big jumps and then big dumps? And I think what they claim is that it was kind of manufactured for the benefit of insiders, family members, whatever. And they would had this kind of arrangement. They would enter it into a negotiations, entered into a LOI, and they would never complete it. When they would enter into a LOI, the stock would pump and they would sell, and then the transaction wouldn't happen and the stock would dump. I think that's the suggestion I got from what's referenced in here. They do look at the issue. They don't make a determination about whether shorting didn't play a role, but they think a lot of it was that there were insiders and family members that were just selling huge chunks at high prices. In effect, they were basically shorting the stock. I mean, you can call it whatever you want, but that's what they were doing. And not only that, they had accumulated literally stock certificates. So Reichman had I guess thousands of shares of stock stuck in a drawer. And if you were the shareholder, you didn't have the stock certificate. So you couldn't trade the stock. So he would lock you in. They would sell, they would keep you stuck. They even think a lot of those people don't even know they had shares, because there was concern that some of these people might have had 5%, more than a 5% ownership in the shares. And they had to be careful, because if there's more than a 5% ownership, then they have to file, I think it's a 13G form. They have to give a notice. And they didn't. They didn't. So is that a crime to circumvent securities laws by showing that you don't have 5%? Probably. I'm not a criminal lawyer, not a securities lawyer, but I would think that certainly smells, of trying to circumvent those rules. One of the events they talk about was that in I think it's 2020, they hired some company basically to pitch GTII. At that time, GTI had nothing, no revenue, no nothing, and still the stock went up as the guy was pitching it. And he probably got shares. I think that the company got shares. That was the exchange. Page 9 of 41, kind of line 7. That's where I am now. Basically, it kind of describes what I just mentioned. Each time, and I'm reading from it now, each time a pattern engaged, GTII would announce a potential deal, then a transaction letter of intent was announced, time would elapse, press releases would go out, and nothing would happen. Each time, GTII, and specifically Mr. Reichman, would then scuttle the deal for some reason or another, and then announce a new potential transaction, letter of intent, etc. And then he sometimes would engage in litigation with these parties, and they'd say they'd be entitled to shares or not. But the point I think that's being discussed here is they would do this, and the impact was every time a deal was announced, the investors would get all excited. It would potentially pump up the stock price, and that's when they would sell. And that's in one way how they could generate a lot of money. And that's what the report is suggesting on page 9 of that. And at the bottom of page 9, this is for Ham the short killer, directly for him. So he has so he could take credit for this in this reference. It references the concentrated short position that Alpine has, that they say the SEC, I think it was the DTCC, actually. And I don't know how many C's there are in DTCC. I think there's as many C's as you can get. But basically, they talk about the concentrated short position. And the Receivers Council doesn't know if the concentrated short position is the reason for the volatility. Doesn't rule it out. But he thinks more of the selling by the family and insiders is what caused the volatility. But he does reference it in here, and I think it's the first time, probably the first time in any case involving a case associated with Alpine that the concentrated short position has been mentioned, I believe.
Well, I'm more worried. I'm not worried. I'm more flabbergasted by that last sentence.
Which
other rumors suggest that officers and directors, as well as insiders, may have been behind the short positions.
Yeah, that's true. There's, so there's rumors. I heard those too. There were claims that and I don't know. I have no idea. But there were claims all along that maybe the insiders were involved. The fact that the insiders made so much money, and I don't think all of them would be the same. Because I've heard descriptions about the Reichmans. I don't think there are any in the report. In this report, I think the way it's phrased is it attributes almost all the misconduct to Mr. Reichman and the board, and attributes Justine's conduct as kind of going along with her father. It's really kind of, that's how it's portrayed. That's no defense, but I don't think she, the way it's portrayed in this report, it's not like she was actively planning it. It appears like somebody, though, was actively planning it to avoid, example, like the 5% requirement and doing those kind of things. And there was one time, for example, where Justine owned a certain amount of shares. There had to be a filing, an SEC filing. Right before the SEC filing, her shares were transferred to a brokerage in the name of a brokerage, so it didn't show up in her name. And then right after that, it was returned back to her name. So it sounds like there was a bunch, according to this report, it sounds like there was a bunch of transactions going on in an attempt to conceal and hide not only the misconduct, but who was involved in the misconduct. And it's clear. The receiver, multiple times references that in the report. So just continuing on, now on page 10 of 41, talking about the officers and directors and the joint liability, they kind of basically says, listen, this is not a big company, and if things were going on, you had to know what was going on. And not only that, there are things that occurred where there was actually active participation by officers and directors. There's no way to work around that. And there's a lot of stuff. Some of it is kind of not. It's not. It's more just kind of redundant. Page 12 of 41. It talks about all the companies, all the subsidiaries that GTII set up for whatever reason that never conducted any business. And I think there's a list of 9 of them, including Dream On Entertainment. And we talked about .8, right? So if you look at Dream On Entertainment, wow, it's .8. They actually had a .8 Wyoming and a .8 Nevada, just to kind of make things confusing. Now, if when you look at this report, you want to kind of simplify it that somebody was trying to pull a fast one, in the very last document in this report, and I'm not skipping to it, but I'm just going to say, if you just want to see if somebody's trying to pull a fast one, there's a chart set up of where things are going. It's like looking at the universe on a clear, if you're in the mountains on a clear night and you're looking at the stars, that's what this chart looks like. It looks like clearly an attempt to hide and circumvent. So please, when you get a chance to look at the report, just go to Exhibit A at the end to see what was set up to try to pull this nonsense off. So that suggests to me not unintentional, seems like purely intentional. It would be interesting, again, on a witness stand, how somebody would be able to justify that. I don't know. Were you going to say something?
I was just thinking, if 10% of what's in this document is accurate, he's not sitting for a deposition for you. They're going to want to get the hell out of this so fast, it's not even funny.
Well, I think logically speaking, I don't know why somebody would want to be in this case to this point.
My God.
Why would somebody want to be in this case to this point in time? Why would you I don't understand that, really. Even if you believed it was bullshit, what's going to happen from this point in time. The receiver thinks you're dead to rights, really. According to this report, the receiver says you're guilty as sin.
Yeah,
so
yeah.
I don't see how prolonging that benefits somebody who's in that position.
Richard, here's what I'm going to say.
Yeah.
Let me. I got to get a drink. I'm so parched. I was doing yard work all day. Let me just get my drink. Hold on.
JR is getting his drink right now. What kind of drink do you think JR has? Any comments? Any comments on JR's drink?
we were talking about this prior to the start of the show. I had gotten a phone call from someone, and they had asked me, what my thoughts were on Richard getting involved. And I said, well, things are going to start to move quickly. And, we had that exchange. And I know you like to be a thorn in people's sides, and that's awesome. But holy shit, man, you got so much ammunition in this report. It's not even funny.
I mean,
This
was
is
thinking about
ridiculous.
I would just take this out in a deposition, and what are you going to do? I literally, how would I prepare for a deposition? I would copy the receiver's report. That's my exhibit 1. That's all I don't have to look at anything else.
If I am representing one of those folks listed in this report that are, have the appearance of, questionable business practices here, I am telling them, you do not want to sit down in this deposition. You need to, whatever they're asking for back, you need to give it back.
Yeah, because I don't, again, this is my thought process. And I'm just thinking as a lawyer, if I have a client, and I've had clients, that not every client I've represented has been on the right side, obviously. So if I have a client that's in trouble, I try to give them helpful advice. I try to make them not make their situation worse. And I don't understand how by not resolving this, especially because the status is going to change. Again, my involvement changes this whether they like it or not. It changes the character of what's going to happen from this point in time. I'm not going to be so concerned about. Listen, there's no reason to be concerned for these people. They've, according to the receiver, they don't deserve our sympathies. They don't. And so, to the extent that they expect it, it's an inappropriate request. It's almost like sociopathic. Why would anybody think that this is okay conduct and that you should be entitled to any sympathy or any kind of relief in any sense?
I think people in this document need to be worried about the SEC coming down on them, and they need to be worried about the IRS coming down on them. Big time.
I think they have a lot of concerns, and but again, I think whether I say anything or not, those concerns exist. And again, I think by playing this out, they're just exposing themselves. Because what's going to happen? The receiver's going to do another report. It's going to have some more stuff. It's not going to be better. It's not going to be
I think you need to file a motion with the court to seize all of their assets right now.
Before we finish,
I'd reach out to their attorneys and I would tell them you're filing a motion to seize everything based on this report.
So just moving on the report, and again, I'm just continuing, just so we have an idea. Page 13 of 41, and I'm not covering everything. I'm just kind of bounce around.
Yeah, I'm good. 13 of 41.
Just to give flavor. It talks about all the entities that apparently David Reitman set up and controlled, and this is where shares would go. I'm counting 4, so it's A through S. S is
through S.
So that's 22. I think that's 22.
There's only 26 letters in the alphabet.
So 20. So it's 20. 20. I was estimating. Come on, it's hard to count backwards. 20 that they found. That apparently are entities where they were. Apparently the receiver thinks stock was being stashed or sent to there. And these are all entities that are owned and controlled all around the country. And kind of when I told you about that Exhibit A, that list and kind of the diagram, this is kind of it. So like when somebody sends up 20 entities that they control to submit stock, I mean, what does that make you think?
This is like he punched in, a random company name finder. Like, I mean,
Joe Blow.
Ricky Deserved Incorporated. What the fuck is that?
Oh, we haven't got to we have a fun one coming up too, by the way. So now at the bottom of page 14, it talks about a company was set up called Ludicrous. Ludicrous is right. It's ludicrous. This whole situation is ludicrous.
The whole fucking situation's ludicrous.
Right. And Ludicrous was acquired by GTII. Now, Ludicrous, of course, did nothing. And it's just happened to be that Justine Reichman was a shareholder of Ludicrous.
Oh, imagine that.
How do you like that?
How convenient.
2016, and nobody really knew about this.
What is Justine Reichman's education and professional background?
I do not know.
Does anybody know?
I do not know. I don't think she's an expert.
Well, she was running a company.
I know. I don't think she's like a tech expert. I think that's what she got paid for, is being a tech expert. She showed, I think it's referenced in here, by the way. She showed apparently Reichman how to use DocuSign and suggested that they use Gmail. And here's 8 million shares.
He called her for IT advice, and she said, and I quote, "Did you reboot it?"
8 million shares. There you go. Great job. Great job. Yeah. So as of 2008, it showed, by the way, that Ms. Reichman owned 8,600,000 shares. Somehow that disappeared from public disclosure. Her ownership kind of ceased, went elsewhere. In 2009, there's another agreement with a company. Nothing happens. 2012, a reverse split. 2012, the company got renamed. It was then Treetop, a subsidiary. So what you'll see is like there'll be a company and a subsidiary and another company. And the only reason anybody is doing that is to be deceptive. There's no
show game. They're just moving assets
that's
around.
all it is. Nobody does that, especially with a company that has zero. This is not like we're talking about anything with an asset. It's got no assets. This is not like we're talking about business income. This is,
and
like,
what assets they did have came from GTII.
Yeah, it's shares. We're selling shares. So how do we? That's all they're doing.
Yeah.
So I mean, a joke. March of 2016, they create Dream On Entertainment.Y as a wholly owned subsidiary of GTII. And they, of course, got shares and eventually got more shares and ended up, that was the problem. That's what got us delisted. You will see in this report, the reason why GTII was delisted, according to the receiver's report, and this should piss everybody off, was Reichman's giving those shares to his daughter. And Reichman listing himself, it's .8. Showed .8, apparently he made an error or some goof. He showed up as an officer on .8. The OTC saw it, and they knew there was some shenanigans going on. And the shenanigans were the shares that were going to Justine Insider, according to this report. And then Kathy Griffin tried to fix it, but she fucked it up too. And as a result,
shocker.
And as a result, or at least according to the report, she screwed it up. That's what the report suggests. I don't know.
What page are you on? What page are you on?
Oh, I went ahead. I haven't got there yet. I don't know what happened, but that's what the report says. And we talked about why we got delisted, why we can't trade it. It's because of this insider trading according to this report, it's purely the Reichmans with the officers and directors assisting. That is it. And they all screwed us. And it's in this report. And it's disgusting.
They're fucking going to jail.
If that's the way it goes, then that's the way it goes. And if they don't know at this point in time, then F them. Really. And if their attorneys are upset that the receiver found out about it, then tough.
Yeah.
Now,
I agree. I mean, everyone's entitled to a defense, but this is fucking bullshit. I mean, these guys were using this as their personal piggy bank. They were living the lifestyle that no shareholder that we're associated with has ever been living. I mean, Bentleys and condo at the Beverly Hills Hilton. I mean, that shit's not cheap.
Well, I'll go one step farther. If the Reichmans think this stuff is bullshit, if the receiver's report is full of lies and inaccuracies, then go after the receiver. Sue the receiver. If he's defamed you, if he's set out a report that's defamatory, untrue, go after him. Establish the truth if that's the case.
Right.
But according to this report, not a lot of good stuff happened. And
provide the documents that show that this report is false.
Yeah, anything. Listen, if it's made up, then you should be standing up, right? I mean, this is damning. If this is false, then come on.
That's right.
So the receiver thinks that like the water, I don't know why, but the receiver thinks that the watershed date was July of 2016. That kind of period of time is kind of when they went full bore on only benefiting themselves. And like so I'm on page 16. On May 9th, they issued a bunch of shares, a bunch of shares. One of them was like almost 30 million to David Reichman. There's 900,000 to the woman that he had a romantic relationship to. Donald Gilbert, who was an officer and director, got 1.5 million shares, 1.575. I don't even know what he did, by the way. I don't know what any of these people did. And I think the receiver questions they did anything. They did any competent services or any services. But what's interesting here, just what caught your attention? Are you looking at page 16?
Yeah. I'm just starting to read it.
Look at number 4, May 9th, 2016. Look at item number 4.
$22,500 shares to Paul Pelosi Jr.
Yeah. So Paul Pelosi Jr. is Nancy Pelosi's son. Which is interesting. I don't know if they still have those shares. I don't know if that's like a interesting point of contact. Should somebody reach out to the Pelosi's and find out, what they knew, or, maybe they don't want the shares, I don't know. It caught my attention. And then in May 16th, there's another distribution of a whole blank load of shares. And then I was talking about how they were trying to disguise the distribution of certain shares. I'm on page 17 now. They talk about in May 16th of 2016, both Kathy Griffin and Reichman get 1 million shares each. Reichman gives 1 million to Justine, and Kathy Griffin gives 1 million to her 2 daughters, split in half, 500,000, 500,000. There's no corporate records that reflect that. There's nothing, nothing. And there's no documents, whatever. So they tried, in essence, what they were doing was trying to conceal it when they were or at least that's what it appears to be. Now, when they were asked about what they did, they said they did a PowerPoint presentation. Why did they get 500,000 shares each? They did a power presentation in 2012 on the threat of toxic waste on people and on the planet. And for that, they were given 1 million shares.
Again, reasonable business judgment.
Well, also it says 2012. That's kind of like a weird time frame. That again, I don't. But that's
I remember the environment at that point being a real problem.
Okay. So on page 18, when I was asking, what's the basis for
just for the record, I do PowerPoint presentations all the time, and I don't fucking get paid that.
When asked about what she had done to, this is page 18 of 41. When asked what she did to deserve the share she got, she references DocuSign and advising. This is what I said before. Advising Reichman on whether Gmail or Outlook was a preferred email client. I guess that's worth 8 million shares. I got to raise my rates is the problem. This is what it's showing me. If you could get like 8 million shares for that, I think that's a good deal, by the way. I think, it's good pay. That's fair deal.
Oh, whoa. This is some fucking real shit here. The help ended up being trivial, such as explaining the use of DocuSign. But I think the better one is what comes next. Or advising Mr. Reichman on whether Gmail or Outlook was a preferred email client.
I agree.
Hey, Reichman, I'll tell you for free, Outlook is far superior. Far superior.
But ultimately, I think she comes clean on that same page and says, I think she was truthful here. They basically ask her, well, come on, really? And then she says, line 16 through 18 on page 18. Sometimes her father would simply give her shares or put things before her to sign. That's kind of really probably what happened.
Yeah, sometimes her father would simply give her
shares. Her father would give her 8 million shares. I mean, not a lot of people would turn out 8 million shares. But
No, well,
you
look,
know,
I mean, it's her father, so there's a certain level of trust there, right? Your father's not going to screw you.
yeah.
Father's not going to put you in. Your father shouldn't screw you. Shouldn't certainly put you in any type of legal predicament in
Well,
the future.
I would look at it this way. What happens if, like, you were I assume Al Capone had kids. I don't even know that, but I assume he did. So if you're Al Capone's kid, and he's the boss, everybody knows he's a boss, and he gives you a brand new car and like 100 grand in cash, could you might guess that might not be lawful tender? You might guess that.
I
So
I, I feel bad for these daughters because
I do too.
yeah,
I think
they've got to be reading over this and thinking, I can't believe my father did this.
yeah, except that you're also kind of like married to the money, right? You're
Yeah,
getting
well, yeah, you become addicted to it.
yeah. Um, there's talking about here, like there's a backdating of bylaws. This is kind of like throughout backdating of bylaws. So that's on line 18 on page 19. Backdating an agreement on page with dot 8 on page 19, line 14. There's a bunch of stuff that says, they took documents and they made them appear that they were not what they were. So that would be either by date or by content. And I'm just giving you a couple examples. It's throughout the report. Questions about the authenticity of documents. I could read every one, but I don't know. But ultimately, the conclusion is they're giving gifts to the family and the insiders. For example, page 20 of 41. You have to be astounded by now that I'm still talking. I'm halfway through the report. I'm still talking, and it's absurd. It really is absurd. And again,
Yes.
disgusting, really. Who in their right mind would think this is acceptable? Who? Who? What kind of brain would you have to think this was acceptable? Really, it's kind of like unbelievably disturbing. Um, so July of 2019, Susan Fabricio, who was his ex-wife, is given 3 million shares. She's passed away, unfortunately, in 2025. Maybe, from this, who knows about the stress from all this stuff? Who knows? But anyway, she's given 3 million shares, but apparently she gives them back to somebody else in a trust. Eventually, she has to document that, why she got it. It says she ultimately documents it by telephonic meetings, research, and simulation analysis regarding potential market for business development and growth, whatever that is. And basically, the receiver says that any entry reflecting any service by anyone had some generic description that made no sense and was inappropriate, because it wasn't like somebody was charging them like $7. It would be like, here's 3 million bucks for services rendered.
There
That
was
was
no
it.
specifics
That
because they
was it.
didn't fucking do anything. That's why.
Yeah. And at the bottom of 20, they talk about that particular transaction. There was invoicing. Are you looking at this?
No, I just was going to say something, but I thought I better not.
Page 20, line 20. That transaction where it's given to the 3 million shares, they created apparently a fake invoice and a fake note, or they backdated it. Again, this is throughout this report. This is not me concluding this. This is the receiver and their counsel, after doing, a ton of work, going through all the documents and finding this. And, the conclusion, page 20, line 24, the evidence reflects Mr. Reichman's willingness to counterfeit corporate records for personal benefit. It's throughout this document. I mean, I again, astounding. Abruptly, in December 9, 2019, GTII issued Justine Reichman another 8 million shares. And apparently, the way they justified it is they claimed that she had made loans to the company totaling 8 million shares, except there's no minutes, there's no loan documents, there's no disclosure to the SEC. And additionally, and I'm reading now, page 21, line 9. Additionally, neither Ms. Reichman nor GTI had any written evidence of the loans. So this is like stuff people are making it up. This is like literally, how did you get that? A ghost gave it to me. Show us proof of that. I lost it. That's kind of the story here. Maybe my story was better about the ghost, but repeatedly, making up stories and having no support for the, and maybe it's true. Maybe it's true, but after having an opportunity to present your best foot forward, you would think you'd provide evidence, and you haven't done it. So, according to what the receiver says, and they think they still have 8.6 million shares. This is now talking about, now I'm on page 23 of 41, line 5. This is about the delisting, and this is the part that really pissed me off when I saw it, because I didn't know specifically the reason. Starting with line 6. So on what it says on April 10th, 2023, the company disclosed that it received a notice from the OTC Markets Group that its common shares would be moved from the OTC market to the pink sheets due to continued concerns on the accuracy or adequacy of the company's disclosures, including its reporting of insider transactions and beneficial ownership. What was undisclosed, unless I'm reading from line 10, what was undisclosed is the actual concerns raised by the OTC is that Ms. Reichman's identity as a significant shareholder had been concealed. That's the reason we were delisted, according to the receivership. We wouldn't be here, literally. We wouldn't be here, stuck with our shares, stuck with all these people having lost their money. Everybody out there, if that hadn't been the case, if they had been above board, apparently, according to the reflection of the OTC, if they hadn't been pulling games about who owned shares, and again, the receiver here suggests, and if you look at page 23, line 20, that an issue was about the 5% ownership, and the receiver, I think, is speculating they were trying to keep, at least on the books, as an appearance that there was not 5% ownership, so they wouldn't have to file a 13G, so nobody would know what was going on. That was the idea, I think. No other reason.
Well, sure, because if she shows up on the books, it's going to be a fucking neon sign that there's something going on.
Yeah. And, when talking about the shares, looking at now page 20, and again, I'm just jumping around, so I'm just giving you highlights. There's a lot more content than I'm talking about, but, it's kind of duplicative at the time. If I tell you one transaction, there was 10, kind of. Page 24 talks about Ms. Griffin, that she altered a no-bo list and to remove Ms. Reichman's name. In essence, it appears to kind of protect her, keep her out of it. And then there's a note, apparently, that, and again, you probably should erase these notes if you don't want them known. But apparently there's a note from Ms. Griffin. This is line 22 through 24 on page 24 of 41. And it says, to Ms. Griffin tells Mr. Reichman, this is in quotation marks, don't save it in the share drive or anywhere else. I don't think it could ever revert, but don't want to take any chance. Close quotes. Wow. I mean, does that sound like somebody is trying to be transparent? Again, maybe there's an excuse, but it kind of sounds consistent pattern of I'm trying to be like, as nice as I can.
She's concerned if she saves it on the share drive that when someone else opens it, it might actually revert back to the current version that she deleted.
Yes.
That's what she's talking about. That's what her concern is.
Yeah. Bottom of 24.
She should have asked Reichman, Mrs. Justine, for IT services.
Bottom of 24, it talks about in 21 and 22. Oh, part of the problem is the way they had to, I should have mentioned this. All the shares were restricted. So the way they could get to sell the shares, they had to have an attorney unrestrict them.
I saw that.
Yeah, and they would only unrestrict the shares they wanted to sell. So, for example, bottom of 24, 41, line 25, two attorneys, Michael Bruck, I think, B-R-U-K, and Markowitz, in 21 and 22, issued 144 opinions lifting restrictions on both 8Y, which was owned or controlled by Reichman, and GTI shares. And as a result, they were able to sell those shares. And in return, they gave Mr. Brook a release. They released him from any liability, which is interesting. You know, if somebody is released, there's usually a reason for the release. It's not just because I'm a great guy. There, you know, there might be something. It talks about on page 25, kind of repeats what I talked to you about the OTC asking about GTIR. It acquired, so page 25 of 41, line 3, OTC is asking about .8Y and who owns it. David Reichman has concerns that GTI has failed to disclose Reichman's involvement with .8 because he's listed as an officer, but they own, it's a subsidiary, so it's all over the place. Then Kathy Griffin, again, you know, they're trying to figure out a way, I guess, of justifying this, of keeping it quiet. So page 25 of 41, line 12, it says Griffin responds that there were services provided in 2011 and 2012. Obviously, there weren't. Eventually, and this is line 17, Griffin tells the OTC that Reichman wasn't was simply assisting his daughter with the filings, and it was a mistake. The OTC must not have thought that was true because the next sentence is April 10, 2023, they removed them from the OTC because they deemed what had gone on involving .8, who owned .8, Justine, Kathy Griffin, all these people, as reflected on page 24 and 25 of this receiver's report, they determined, and I'm reading, as its inclusion would impair the integrity of the market. The stated reason was a continued concern over reporting, quotation marks, insider transactions and beneficial ownership, close quotation marks. We know that was what was discussed about the Reichmans. That's what it is. And in June of 2023, GTII caused its counsel, I don't know if they caused their counsel, maybe they asked their counsel.
Yeah.
To say something about .8, and apparently what they said was not true. And obviously, you know, we know where we are today, right? We can't trade it. We know what the report says. Seems pretty clear why we can't trade it. And everybody was involved, all the agents, all the attorneys, all the scumbags that helped assist the shenanigans, you know, they should all be accountable. Page 26 of 41. The thought was Reichman claims that he's entitled to compensation. I don't know for what, but let's just say he was entitled to compensation. Let's say he did something. Let's say that GTI actually did something, made $1, and he was entitled to, you know, whatever over all the years. Page 26 of 41 says, okay, let's assume that that was the case. You'd still be entitled, you'd still be obligated for, oh no, it's a different chart. I'm ahead of myself. This particular chart says that Ms. Reichman I'm on page 26 of 41, line 21, sold shares between 21 and 22, totaling $8 million.
Yeah.
So, you know, you expressed, you know, sympathy for Justine, you know, being with a father. You expressed it. $8 million is a lot of sympathy.
Yeah,
right?
it was that much sympathy.
Okay. And, you know, there's a bunch of problems because the tax returns would show. So, you know, when I'm saying that documents are all over the place, so they might say that one entity is not affiliated with one entity, and then on the tax return, it would show that affiliation. That's kind of how it suggests in the receiver's report throughout. So eventually, Justine sold all her GTI stock, got rid of it completely, exchanged it for a blue chip portfolio of stock sitting in a company called Paris International. I'm on page 27 of 41, line 1. Paris International brokerage firm, and it was about $2 million. I don't know where that is now. I don't know who has control over that. I hope the receiver is pursuing it. to this point in time. It also says, during those times, she spent in total, and it appears that this was reimbursed or was from stock proceeds. I think more of GTI stock proceeds that the receiver would claim that she's not entitled to. $1.3 million on American Express, $1.4 million in Citibank. That's a lot of dough. Honestly,
in less than 3 years.
Yeah, that's a lot of dough. A lot of dough. Talks about Warren Markowitz, page 27. He was a lawyer I mentioned before. He did the deal where the profit sharing plan apparently sold 10 million shares. It generated $2 million, 1.8 to David, 200,000 to Markowitz. I don't know what the receiver is doing as to Markowitz. The $1.8 million for David, I have no idea. But that didn't just stay with David. If you go to page 28, it shows that some of that money was distributed. Justine got $250,000 on September 6th. Her company got $250,000 on November 6th. Her other company got $500,000 on September 21. Then there's a bunch of other expenditures, various amounts. Then there's a bunch of Zelle payments, not insignificant. If you go to page 29, there's another Amex bill for $87,000. Luckily, thankfully, we're paying for somebody's Saks Fifth Avenue bill of $21,000 too. All this, listen, from this report, all this is coming from GTII. All this is coming out of JR's pocket, literally, directly out of the pocket. No other place. Everybody on this place has basically funded Justine's lifestyle and David's lifestyle, according to this report. And again, if this report is inaccurate, I urge counsel for David and Justine to go after the receiver. Go after and tackle them. If they're bullshitting, prove them to be the bullshitter. If you have evidence this is false, then show it.
So let's take a step back. So where did the receiver get all this information from? They did a forensic analysis of all the bank accounts, stock transfers, Justine's deposition, right?
Yes.
It says in here that she admitted to some of this stuff.
Yes. Yeah.
So
I think I'm on behalf of .8, not an individual. But
on behalf of .8.
Yeah,
.8 was her, or she is .8.
Yeah, they have an auditor and they have a forensic accountant. So they have two different people. And it's, again, if you look at Exhibit A, if you don't want to look at the report, just look at Exhibit A. And if you look at that and you try to, have you looked at Exhibit A yet, JR?
No, I'm on page 29 of 41.
Yeah, skip just Exhibit A just for a second, just for a second. It's 42, I think.
$42.
Yeah, it's Exhibit A. It's at the end, very end of the document.
The very end of the document for me is the signed page.
Oh, okay. Well, there is a document. All I'm saying is, if you get this document, look at Exhibit A. You will see like a chart. You should have it, by the way. You should have there'll be a chart, and on the chart is you'll see how complicated it is. Mark Richardson, the receiver accuses him, an attorney, of laundering money in stock sales for GTII. And he claims, the receiver claims at page 29 of 41, that it was, and again, this is the receiver's analysis through his auditor, through his counsel, through a forensic accountant, and through every other witnesses they have, and I'm sure they have witnesses, that they did $3.5 million in stock sales of laundering, and of that, Reichman got 90%, kind of what I told you at the beginning, and Richardson, according to page 29, line 20, he got $561,000 for doing that great job. There's a chart, it's listed on page 30, and there was something then we talk about page 31 of 41, we talk about the properties. There's two properties. One is a property in Northern California. One is a condo in Los Angeles, in West Los Angeles. The receiver believes that both properties were obtained through the use of funds that were generated through the sale of GTII stock. And
Seems to
so,
be a recurring theme here.
yeah. So there's a whole series of transactions or cash transactions that are referenced how the property was acquired. And originally, the property apparently was going to be in David Reichman's name, and then they decided to put it in the name of a trust, Justine Reichman Trust. Now I know David Reichman has agreed to a Liz pendants on his condo. That was apparently all paid through GTII money, including the renovation, the remodeling of the condo. But if there's a Liz pendants, he can't do anything with it, so he's stuck with it, and he's obligated to pay whatever the monthly obligations are. It must be a nice condo. I saw the view. It's in a nice part of Los Angeles. I think if I added the
Said the
number,
Beverly Hills Hilton.
no, he's actually got a condo he bought. So he was he was living at the Beverly Hilton, but he also bought a condo. Listen, if you had money, that kind of source of funds, you could buy a lot of stuff. And they use money. They use GTIF funds to remodel it. And when the property in Northern California, the issue is, I think the issue is, so my view is that they should pursue a Liz pendants. The attorneys for the receiver have a different view. They think because the money came in and there wasn't title until a subsequent transfer, that the only thing they can go after would be the money. So, and that a Liz pendants would be not appropriate. I believe I'm correct, but they can have they're entitled to their opinion, and they have more at risk than I. They're on the hook.
I think you should go after all of it. Jesus, everything.
But anyway, I think they're trying to resolve things. So, maybe that will eventually come about. But I think a Liz pendant should have been filed as to the Northern California property. And like I said, Receivers Council disagrees with me. I understand their position. I just disagree with their position. So, but I understand it, and that happens. But she bought there's a property in Northern California, Justine, or a trust related to Justine owns, and I think she's paid for like $2.5 million. That probably has a bunch of equity. And David's property has a Liz pendants on it in Los Angeles. That's page 32. Page 32, there's a guy named Arthur Schwartz. Apparently, according to the receiver, now looking on page 33, after Schwartz died, apparently there were accounts and credit cards that were opened up in an alter ego name of Arthur Schwartz, and that GTII paid. This is page 33. Some of this is like ridiculous. Page 33, line 10. Arthur Schwartz dies. After he dies, again, he continues to incur expenses. GTI pays those expenses. They continue to pay the expenses of a dead guy. Who was using those cards? I wonder. The receiver suggests that it was David Reichman. Come on.
I actually think starting on line 26 is pretty interesting. Did you see? It should be noted that the 3.1 million shares issued in 2020 to David Reichman was mainly due to salary and wages. As such, a W-2 should have been issued for that portion of the stock represented salary and wages. It will be interesting to learn if David Reichman paid income tax on those wages and wherever taxes would have been due on the exercise of the stock options. Yes, it will be interesting.
Yeah, that might be a question that comes up more than once. But but the fact that the GTI is paying the expenses of a dead guy, I think that's inappropriate. That's where I draw the line. I don't pay.
It's not the Bentley, not the properties, but damn it, paying the expenses on a dead guy.
Dead guy.
That is bullshit.
That's not acceptable. And then we got, this is the part where I mentioned before, page 34 or 41. We're almost at the end. That notwithstanding whatever money he might have been entitled to in the analysis, he still would owe $3.6 million. So You got overpaid by $3.6 million, even if you were entitled to a dime. And I don't think you're
Here's the
entitled
question: what the fuck was he doing?
I
There was
think
no income coming in. What
I
was
think
he working on?
well, if he was spending, if they were spending a lot of money, then he was living a nice life
On what?
on
Yeah, a
selling
nice
stock.
life.
Selling
What
stock.
what work was produced from Mr. Reich?
Come on, selling stock. That's the work. That's a job. That's a job.
Clearly.
I'm trying to think if there's anything else in there. They think he might have violated the Sarbanes-Oxley.
At this point, SOX is the least of his concerns.
They asked the prior auditors, "You ever heard of Dream On Entertainment or Dot 8?" They said no, never even heard of them. So I don't know what was disclosed, what was not disclosed.
I know this is probably a stupid question, but it just popped into my head. How were they paying for? Was health insurance being provided to these through the company? Do we know?
There's only
Health insurance?
Only two employees.
No.
David and Kathy Griffin. So
interesting.
No offices. Page 36 of 41. So this is like the receiver's conclusion, kind of what I've said that he said, but it is our belief that GTI's former directors and officers may have committed tax fraud by not properly reporting compensation to the IRS. That may explain why no W-2s exist.
Wow.
It is what it is. They talk about, even after the minute order. So when the receivership, this just tells you, no shame, whatever. Again, according to the report, when the receivership was set up and the judge issued a minute order. So the minute order says, we had a hearing today and we found the receivership's going to be established. No shit's going to go on from here. After that, he still used GTI money. He still spent, they on the order of, I see two numbers. One's 89,000, one's 43,000. I don't know which one's which, but that was subsequent to the court order, apparently. That would be bad if you were doing that. That wouldn't be really a good thing. Talks about the subpoena I mentioned to the architect. They finally served them. And that's basically the summary. That's just a few of, not all the details, but a few of the details. And ultimately the conclusion is the receiver says, got more to do and they got to keep on going. And they're, working on getting the shares back and the money back. Now, I also know, and I referenced it before, and it's referenced in the report, that there was another motion that's going to be filed that's going to be as to the shares themselves. And it's referenced in here like it was filed. I don't believe it's been filed, but it's obviously going to be filed in the short term. I would presume if it hasn't been filed, it will be filed this week. And I think I mentioned that was like something that needed to be filed in order for this transaction, if it closes, that it can close. And the other thing that I guess that might happen is the issue about the audit and requiring people to sign off on the audit. But after that, kind of like just hitting some of the high points that the receiver has found based upon, again, an auditing team, a forensic accountant, a bunch of lawyers, bunch of subpoenas. There was a bunch of subpoenas that went out, and documents were obtained by various sources. Through that's what's generating. This is the fourth report. So again, if this is false, if this is untrue, then I urge all the people that have been defamed to go after whoever put out this false report. If it's not false, then be smart and get this done. Really. Because this is not going to end well. It's not. Who would think, honestly, who would think that this is going to end well with these facts? There's no benefit, really. I think Monday you should be calling your lawyers and trying to get this done this week. Really.
Yeah.
I mean,
Monday.
Not legal advice.
Done it first thing this morning.
Yeah, not legal advice, but
actually, if I were representing him, I would have fucking called him and said, dude, are you? Yeah, I mean, if this, again, I don't know the person. I've never met Reichman, but if I were in front of him and he was my attorney, I would say, are you out of your fucking mind? That's what I would say. And I'd meet it 100%. And I told somebody, by the way, I had somebody that recently I was involved in a little dispute. I was helping somebody out. And
my client was talking too much. I wasn't even there. I was on the phone really at a meeting, but I wasn't present. So I had a conversation with an attorney. We resolved it in like 2 minutes, the issue. And my client wouldn't shut up. So I put him on the phone. I said, put my client on the phone. I told him, shut the fuck up. Is what I told him. Literally, I said, listen, sometimes you just got to be smart. And, sometimes you got a bad hand. You got to make the best of a bad hand.
Yeah.
If I don't see how prolonging this in any fashion benefits these guys at all. I don't. Because nothing else, we're going to have these conversations. Every time the receiver puts out a report, every time there's a motion, every time I get involved in anything in this case from this point forward, it's going to be discussed.
Right here.
If it's in the court record, it's going to be discussed. It's going to be discussed. So, and since it's discussed and since it's disgusting, they really should resolve it. Anyway.
These reports get sent to the SEC, right? I thought they do. Yeah, no, they do, because everyone he's done, he's filed a
8K.
He's filed a 10K.
Yeah, if there's a filing, then yeah, but we don't know if the SEC actually reads it. I mean,
they probably don't.
I went through it. If you didn't know anything and you tried to follow this, it's not possible. You wouldn't be able to.
People are asking if there's a copy available. Is there a copy available, Richard?
I sent it to you. Could you post it?
No, I can't post PDFs.
Okay, I will try to post it. If not, I will have the.
Well, I don't think you can post PDFs either.
Oh. I'm going to ask the receiver, and the point is, I'm going to ask the receiver to post it on his site.
Yeah, he can probably post it.
Yeah, so the receiver's site is on X. It's GTII at GTII receiver. His email is gtireceiver@gmail.com. I'm going to ask him to post it on his site. And if for any reason it's not posted, contact him directly and also remind him. I'm sure he will do it. No reason not to. But again, do it in a nice way. Don't be obnoxious, whatever. It also might come out, as JR said, it's probably likely if it's come out as a SEC filing, it'll come out as an SEC filing. It probably just won't come out till Monday or Tuesday if it's been filed. And I appreciate, again, go through it, get a feel for it on your own. It's really amazing. Honestly, it's amazing. The amount of alleged corruption and misconduct is absurd, really absurd.
It's disgusting.
Yeah. Anyway,
that's really all you can say.
Yeah. So to all you out there, as I started this, because I know it's like crazy when you hear that kind of conduct, you want to like punch a wall. But instead of that, put a comment on it. I'd like to see what your comment is. Express yourself in a gentle way, and but stay on top of this, because we will be from this point in forward, we will be involved in all the legal proceedings. I will be there on the 27th. That's it. So to all you out there who listen to this long ass thing, any questions that you see that you want to? You saw?
No, okay. I didn't see it. There was nothing out there that.
To all you out there that sat through this, thank you very much. If you have comments, questions, please put them in. And, obviously I'll keep you apprised of what happens next. Next hearing is the 27th. I will be attending, and we will go from there. Again, thanks for spending the time with us. And we think this is as crazy and obnoxious as you do. It's just amazing that we have it's in black and white at this point in time. So everybody be well, take care, have a great rest of your weekend, and see you.